Hi, welcome back to Jus Cogens, the International Law Podcast. This is episode 14, and today we are going to talk about the ICJ. In particular, we're going to talk about the case regarding the Gambia versus Myanmar. And today we have with us Dr. Priya Pillai. She's an international law specialist with expertise in the areas of international justice, international human rights, transitional justice, peace and conflict, and humanitarian issues. She currently heads the Asia Justice Coalition Secretariat in Manila, where she's currently based. She has worked at the IFRC, at the United Nations Criminal Tribunal for Former Yugoslavia, ICTY, and various other civil society organizations on the implementation of international law, human rights, rule of law, and transitional justice. Thank you so much, Priya, for joining us on the podcast. It's an absolute pleasure to have you with us today.
Thank you for having me, and I'm really happy to be here and to chat with you all about this really important case.
Great. So just to get started, if you can just tell us a bit about the case itself. How did it come about, and what's its context, and how does the ICJ and its jurisdiction come into play?
Sure. I think, the broader context of this, of course, is the marginalization of a section or an entire population within the context of Myanmar. So I think, you need to go back quite a few years, a few decades even, in terms of the creation of conditions that enable the marginalization of this group called the Rohingya, a Muslim minority that are based in Myanmar. Fast forward to November 2019, and after a lot of speculation, a lot of discussion, it was announced that the Gambia had filed an application before the International Court of Justice alleging violations of the Genocide Convention. At that point, a lot of commentators and a lot of people were asking, how come the Gambia? What's the relationship with the Gambia? Where is it in the context of Myanmar and the Rohingya? And what really is the relationship between the Gambia in this case? I think, of course, the last few years has seen a huge surge in violence and mass atrocities within the context of Rakhine State in Myanmar against the Rohingya. So we've had waves of violence and, really a mass exodus across the border into Bangladesh in 2012, 2016, and August 2017, the anniversary of which we're coming up to. At that time, there was a huge discussion saying, states need to take responsibility. The international community needs to do something, and there are multiple legal options and avenues that are available, and somebody needs to take this to the international courts, whether that's the International Criminal Court, whether that's the International Court of Justice. There are multiple legal avenues that need to be explored. And it was in this context that really the Gambia has stepped up and become a bit of a conscience for the world, saying, what is happening is so egregious and so terrible that we can't sit by and watch this unfold. And if other states aren't going to take the responsibility, we are. So in that context, really the Gambia has come to the International Court of Justice using a really novel legal argument. They have said that we're approaching the court, under Article 36(1), which is the jurisdiction of the court, but also Article 9 of the Genocide Convention, which basically states that if you have a dispute in terms of the interpretation of the convention or the application of violations of the convention, you may approach the International Court of Justice. Now, I think there are a few key things to remember in this. One, of course, is that the Gambia is a signatory to the Genocide Convention, as is Myanmar. The second thing to remember is that both states have not entered reservations to Article 9, which actually is the case for Bangladesh and Malaysia. So, a big question also was, well, why aren't the states that are actually directly impacted by this in terms of refugee flows, in terms of hosting the community, why aren't they approaching the court? I mean, the problem is that you've had this reservation entered into by both these states. So at this point now, we've basically got an application that's been filed at the ICJ, which is using the notion of erga omnes obligations and erga omnes partes obligations. So, a twofold obligation in a way that Gambia is invoking, saying this is such an egregious, terrible violation of the Genocide Convention that as part of the international community of states, we are going to approach the ICJ and we're going to seek relief at the International Court. So that's really the framework of how the Gambia has approached the court, on behalf of the Rohingya.
Thank you for the comprehensive contextualization of the case. So for some of our audience who may not be as familiar with the ongoing parallel proceedings, could you maybe give the audience a brief account of the proceedings in regards to the crime of deportation happening at the ICC and the case under universal jurisdiction in Argentina?
Sure. I mean, you ask a very good point in terms of these multiple legal avenues and cases that are going on. I think, I again go back to that 1 week of November 2019, which was really a momentous week. So on the 11th of November, the International Court of Justice application was filed by the Gambia. On the 13th of November, a universal jurisdiction case was filed in Argentina, so in a domestic court within a national jurisdiction. And of course, on the 14th, the International Criminal Court, Pretrial Chamber 3, approved an investigation. So basically said, there is a reasonable ground to proceed. So the prosecutor needs to proceed with a fairly specific case linked to, international criminal responsibility. So I think maybe a little bit on these other two proceedings would be helpful. I think the first thing to sort of emphasize, of course, is the difference between the ICJ and the ICC. So the International Court of Justice, of course, is about state responsibility. It's about Myanmar as a state and, where and how do you hold Myanmar accountable. Whereas the International Criminal Court is really about individual criminal responsibility. And the stage that the case is at the moment is also actually quite an unusual and path-breaking case, even in the context of the ICC. So, and the reason I say that is because the ICC case is premised on jurisdiction through a state party, which is Bangladesh, but Myanmar is not a state party. So it's a very specific form of jurisdiction that's been used in this case, very unusual, it's not been done before. And one of the previous decisions of the court also was on jurisdiction, whether this was amenable, whether it was appropriate to have jurisdiction via Bangladesh, but for a state that was not a party. So that, there was a jurisdiction decision in 2018 that was basically positive and allowed the prosecutor to sort of continue on her work. And now the limit or the scope of the ICC case is linked to a territorial nexus. So basically it's that the conduct of the crimes needs to continue or needs to be in the territory of Bangladesh as well. So really a continuing component of the crime. Because of this, the crimes right now that the prosecutor is looking at are quite specific. Crimes against humanity of deportation, that's the first one, the most obvious because there's that, cross-border element. But there are other crimes against humanity. So the crime against humanity of persecution, that is also, on the radar of the prosecutor, as well as other inhumane acts. The one thing that I will also say in this is, it's really worth reading the ICC pretrial 3 decision very carefully, because the PTC actually says that, yes, it is cross-border, it's linked to your jurisdiction and territorial nexus, but the door is still open. So if you can, the trial chamber doesn't say it explicitly, but reading between the lines, if you can make the case that there is a territorial nexus, even in the case of an Article 6 crime, so genocide, the door is open to that. So it's now up to the prosecutor in terms of how she wants to approach the case. The obvious are, of course, deportation and 2 or 3 of the other crimes against humanity that have been enumerated by the pretrial chamber. But really, the ball is in the prosecutor's court in terms of the approach that she's going to take for this case. So I think there is scope to expand and to look at it in a slightly more broad manner, but keeping in mind, of course, there needs to be that jurisdiction and the territorial nexus. So yeah, it's a complex case, but there are avenues still open. And of course, the last one, as you mentioned, is a case that is slightly different. It's in a domestic context. It's in an Argentinian court. And I think I would emphasize that it's individual criminal responsibility. And very clearly, the people who are named in that filing right now are Aung San Suu Kyi, as well as a number of the military heads within Myanmar. So again, a very specific case. I believe it's at a stage now where they're waiting for confirmation from the ICC that there won't be an overlap between the cases. But yeah, at this point, we're still waiting to see what happens on that case. So yeah, 3 big legal proceedings going on.
So thank you so much for that, Priya. Priya, just going back a little bit to the sort of intimation that you made in relation to an erga omnes obligation, the obligation of the international community with regards to peremptory norms, Jus Cogens norms. So our viewers watching would probably agree that the international legal order still revolves around states. But how significant is this development where you see the court
essentially accepting the Gambia's standing with regards to erga omnes obligations. And if it's also possible, could you please highlight the evolution of this concept at the ICJ in itself and see how far the ICJ has come?
Sure. I mean, the first thing I would say is, yes, I mean, international law and, international enforcement for sure is very linked to states. But I would disagree a little bit in that I feel that there are other actors now that have a lot more power and clout as well, including individuals, including corporations. I mean, I think you have, there's a broader sort of scope and range of actors as well. But yes, I agree. I mean, states are sort of the primary actors that create and formulate a lot of the rules and the norms. Having said that, I think, in terms of erga omnes obligations, I think the one thing to remember is that this is, of course, the first time, this is the first case before the ICJ where this is being used linked to the Genocide Convention. Now, if you go back a few years, you, of course, have the case of Belgium versus Senegal, where the same concept was used, but under the prohibition of torture. So that was seen as that heinous and, that sort of grave a crime that the International Court of Justice said, yes, there is an option where a state that may not be specially affected or directly implicated by something can approach the court and does have standing. Now, it gets a little complicated where you have there's been a discussion around the fact that, well, in this case, Belgium possibly did have a special interest. Belgium did have a universal jurisdiction law. And by virtue of that universal jurisdiction law, you can actually say that, well, there's a special interest. So it's not really completely free from any interest in the case before the ICJ. But I would actually then really direct you to the International Court of Justice judgment, which in paragraphs, I think, 448 to 450, says very clearly, yes, we see that Belgium has this interest, but we're not taking this into account in our decision-making. We are, in our decision, focusing solely on erga omnes obligations, and by virtue of that, we find that Belgium has standing. So, I think it's evolving jurisprudence as well, and it's fairly novel and it's fairly new, and I think this is going to test the courts because, what is the implication of this? The implication of this subsequently down the line is that other states can approach the ICJ. Clearly, I mean, so is it a matter of the floodgates opening in a way? And you're saying that, by virtue of saying that this is approved by the ICJ, therefore, in other cases, other states are going to come and make claims also under the Torture Convention, also under the Genocide Convention. At least we've got these two for now. But the one thing I will say, of course, is, let's not forget, this case is at a very preliminary stage. So right now, in terms of the order that's come out from the International Court of Justice on the 23rd of January, it's this interim provisional measures order, which allows for standing and basically has allowed the case to proceed. But let's not forget that it's not definitive. It is for the purposes of the provisional measures order that decision has been made. It's not a definitive decision. So, now we have to see going forward whether this still holds and whether the court will still, enable this course of action. So, but it's a very novel and new approach as well, which we need to watch.
Can you talk a bit about the provisional measures? What do they entail, and what are the scope? What is the bindingness, and what implications do they have on compliance from Myanmar?
Yeah, and that's a very important question. So we've talked about the fact that Gambia filed this application as a first part of the application. Of course, the application is about the case and in general what the Gambia wants from the International Court. But there's a very specific part of that application which talks about what is called an interim measure of protection. So really straight off the bat, immediately what you want the court to do. Really a bit like a cease and desist order in a national context or national jurisdiction. And the court typically moves quite fast on a provisional measure application. Having said that, I mean, I will say that even provisional measures in the last 5 years, we've had basically about one provisional order, per year. And I think that the jurisprudence around provisional measures is still also evolving. But coming back to this case, as part of the case, hearings were held in December, where you had, Myanmar and the Gambia present their arguments before the court. On the 23rd of January, the court came out with its decision. And, I'll emphasize that this was a unanimous decision, which included the they're what are called judges ad hoc. So 2 temporary judges that are brought on board by each of the parties. In this case, the 23rd January order included the judge ad hoc for Myanmar as well. So it was a unanimous decision by the court. Article 41 is what enables a state to come to the court and ask for provisional measures. However, Article 75 of the statute also allows the court to come out with measures that may not have been asked for. And the court used that provision in this case. So, some of the measures that were asked for are fairly standard in terms of cessation of hostilities, ensuring that obligations under Articles 2 and 1 of the Genocide Convention are complied with. So these were, of course, part of the order. But 2 things that the court did were really different and really have not been done before, at least to my knowledge, by the court. The first was it actually said there is an obligation on Myanmar to preserve evidence and to ensure that evidence of atrocities is not destroyed. That was one. And the second one is basically, and this is where it becomes a much more activist court in a way, or it's taken on a supervisory role, where it's basically said Myanmar is to submit a report on compliance with this order within 4 months. So that was May 2020, and for 6 months thereafter, till the conclusion of the case. So what we know now is, that Myanmar has in fact submitted its order in May 2020. There is a huge clamor now with civil society organizations, with victims groups to say, we want that order to be made public. At the moment, it is still, within the confines of the court. So that's one ongoing discussion that's happening. In terms of implementation, I mean, this is, as we all talk about the real problems with international law, this is something that is definitely a problem. Now, the court has taken on a supervisory role. And this is where I see a bit of a slippery slope, where it said, okay, make sure that you implement this order, let us know what you're doing, but then what? What can the court do if this is not complied with? And unfortunately, we've seen, from January, February, in fact, immediately after the order came out, the next few months, there has been a surge of violence. There have been, shellings against civilians. There have been civilian deaths. This is something that's ongoing. I think just 2 days ago, there again are instances of mass atrocities being committed. So in terms of the letter and the spirit of implementation, I mean, Myanmar, of course, is going to say it is sticking to the order and it is complying. But whether that is in fact happening is an open question. And the one thing I'll add to that actually is that one of the requests from the Gambia was, as part of its provisional measures, was to allow fact-finding missions and to allow the UN access. And of course, that was not addressed by the court, and that was not part of the provisional measures order. So yeah, I mean, I think implementation is going to be an issue. But having said that, I would still say that this is a provisional measures order that is very strong. It is legally binding, in law. For the statute, it is something that a state can't shirk, and a state can't just say, we're not going to bother. It is something that is a legal obligation. So it has a lot of force inherent in it.
So Priya, about you mentioned the legal binding nature of this ruling, essentially, with this provisional measure. Do you think there's some other recourse to ensure compliance, perhaps through Article 94 of the UN Charter? And do you see the United Nations Security Council stepping in, given the realpolitik of it all as well? Maybe if you had some input on that.
Yeah. Well, the UN Security Council really should be stepping up, and the UN Security Council should have stepped up quite some time ago. I mean, I think, we all know the political context of the UN Security Council, and we know that, I think just the fact that it took 90 plus days for the UN Security Council to come up with a resolution on COVID shows some of the dysfunction of the council. But having said that, I mean, I would say the Security Council cannot be let off the hook. It still is the primary sort of arbiter of international peace and security. It has obligations under Chapter 7. It has obligations under the UN Charter. So it really should be stepping up as well in terms of, ensuring that the obligations inherent in this provisional measures order are complied with. But I think we all know that there are a lot of problems in the functioning of the Security Council right now. So, as always, you have theory and what is there and what is legally sort of necessary. And then you have the implementation and the enforcement, which sometimes lags far behind, really. So yeah, definitely problematic. I mean, the one thing I will also say is separate from the ICJ is the fact that the ICC right now has this limited case before it, but that's not to say that there should not be a larger Security Council referral to the ICC. So that is still something that is on the agenda, and that, you know, many states and civil society organizations are still pushing for. And what I will also say is that if you look at the Pretrial Chamber 3 decision of November, it also refers to the fact that a limited case is moving forward and there's authorization to investigate doesn't preclude a wider referral by the UN Security Council. So that's, again, a very clear signal that, you know, the UN Security Council, this is something you're meant to do. But of course, we've seen the only 2 referrals so far are Sudan in 2005 and Libya in 2011. And, you know, again, you have problems in terms of enforcement and next steps. But at least that referral was done, you know, I think that is an important step. It's an important signal as well.
Right. So taking the sort of the point of access to fact-finding missions, we've seen that in the past genocide cases, we've had findings from the ICTY which were relied upon by the court and given a great weight. So in this case, we saw sort of the Gambia relying a lot on the independent international fact-finding commission. And so how do you see it in light of the broader context, considering there are no rules on admissibility of evidence and the broader role of the court in terms of fact-finding, because it doesn't operate like in a criminal court?
Yeah, no, that's a really good question as well. And I think there are increasingly now questions around the fact-finding sort of ability of the court. But actually, let's step back. You know, if you look at the statute of the ICJ and you look at the rules of the court, the statute of the ICJ has Article 48, Article 50, which actually talk about the evidentiary nature of the proceedings, talk about expert opinion, expert evidence. So there are some rules there. You look at the rules of the court, you've got Articles 48, 49, I think Article 60 as well. I need to check that one, but you know, you've got some bare bones in a way. But I think the one thing about the ICJ is that there's a huge amount of flexibility and latitude that the court can use, which is to an extent to its advantage as well. And actually what I would, you know, I was writing a piece on Facebook and Myanmar and, you know, evidentiary issues there. And I came across this statement by Judge Tomka in 2014 to the 6th Committee of the General Assembly, which really was, I mean, it's a brief statement, it's about 8 pages, on the evidentiary and fact-finding nature of the ICJ and what it can do. So, I mean, I would highly urge listeners to actually just go and take a look at that. So, you know, in terms of, and look at some of the cases that the ICJ has had before it. You usually think of cases where it has had scientific questions, so linked to law of the seas, maritime delimitation, boundaries. It's had expert opinion, it's had expert evidence come in. So the ICJ has some sort of familiarity with that. But of course, I think it's very, very different from, you know, an international criminal court that is a finder of fact. I mean, a fundamental key part of what you do when you're sitting in a criminal court is sifting the facts and assessing what is, you know, corroborative, what is complementary, and, you know, those are definitely much more detailed proceedings where you're really looking at facts in detail. So I think, you know, the ICJ is not in the best position in that sense, but having said that, I think maybe the fact that it's got these flexible rules gives it a fair degree of latitude. And that is something that it should use to its advantage, to be honest. I mean, it is something that, you know, it can develop its own standards and procedures. In Judge Tomka's view, you know, it's really very much the standard of proof that is similar to civil proceedings in a national court. So clearly not the same standard of proof or not the same evidentiary burden as a criminal court. But, you know, there is that degree of latitude which the court should use. I would also say that, of course, in the last case under the Genocide Convention, which was Srebrenica and, you know, Bosnia versus Serbia, the fact is that the court came out with its judgment in 2007. By 2001, the Krstić decision by the trial court was already out at the ICTY, which said, yes, genocide occurred. Genocide was, you know, Radislav Krstić was convicted for the crime of genocide at the ICTY, and this was upheld by the appeals chamber in 2004. So the ICJ had that to rely on. Right now, what we've got is concurrent proceedings, and we've got the fact-finding mission, which has delved and come out with detailed reports, which have now been also forwarded on, including the background material, to the IIMM, which is the International Investigative Mechanism for Myanmar. So you've got one more body now that is a repository of information and evidence, and is gathering evidence for future prosecutions wherever they may be. ICC, a regional court, an ad hoc court, in whatever form that eventually happens. So yeah, I mean, you've got multiple fact-finding initiatives right now, and they are overlapping, and it's going to be very interesting to see how these move forward, because these are all sort of concurrent right now, which is not the case for Bosnia versus Serbia. So yeah, even more complicated, I think.
Speaking of evidentiary issues, I have a broader query regarding the admissibility of digital evidence in international courts and tribunals, and specifically in this case as well. I remember doing an episode with Dr. Emma Irving, I think it was episode 3, where she talked about the usage of Facebook posts made by the generals of Tatmadaw inciting hate speech against the Rohingyas. But that was in the case of the preliminary investigation by the Office of the Prosecutor. How does that relate to this case at the ICJ? And what do you think are the major challenges of admitting digital evidence in international courts?
Well, I mean, as I said, I don't think there's a bar. I don't think the ICJ statute or rules have a bar to that. And, in terms of the type of evidence that's been presented to them, it's included audiovisual, cassettes in those days, maps. So I don't think there's any bar to that. Now, it's, of course, a little more tricky when you're looking at Facebook. So I think as context for your listeners as well, it's important to note that the Gambia in June went to a US federal court in the District of Columbia to access Facebook's records, to basically say, look, we've got specific Facebook accounts that we would like the background, including posts that have been uploaded, but also posts that were worked on and that were not eventually made public. And we want access to all this information. Last week, Facebook has actually filed its motion in opposition to this case and basically said, look, under US law, we are not obligated to give you any of the information. And then, of course, going under the specific provision of that federal statute, section 1782, a series of arguments about why Facebook should not hand over this information. I think important to note that the Gambia has asked for this information for its ICJ case. So it's trying to collect this evidence and include it and incorporate it in its submissions that it's going to make before the International Court of Justice. So, and that's that is really the crux of the US federal legislation which is being used, which is for foreign or international courts, that you can approach US district court and ask for access to this information. So it's going to be very interesting to see what happens with this case. I mean, I'm not well versed enough with the nitty-gritties of specifically the Stored Communication Act, which is the defense that Facebook is using, saying, look, under this act, we really cannot hand over the information, either enter into a mutual legal assistance treaty. I looked at some of those treaties. Of course, the Gambia doesn't have one with the US. And if you look at the timelines for the treaties, it's really unrealistic. Forget the negotiation timeline that you have of a treaty between signature and ratification. The shortest was 18 months for Israel, which, in terms of political will, that also plays a part. And the longest was 8 years for Ireland. And then you've got, ranges of 5 years and 6 years in between. So, yeah, I mean, I think this is an area that we, definitely needs to be explored further. I do not think there are any bars within the International Court of Justice statute and rules that would preclude such evidence. Now it's a matter of getting that evidence. And I think this is where, there's a stumbling block now with Facebook saying, we're not handing it over. There was, of course, I think a matter of interest. There was a Reuters report which basically said that, Facebook indicated it was communicating and it was in discussions with the IIMM, which is the mechanism for Myanmar, which it would be very valuable for the mechanism to have this information. Reuters just came out with a report day before yesterday, where the head of the mechanism for Myanmar has said, well, actually, we've been discussing this for 1 year with Facebook and we haven't received any information. So yeah, looks like a bit of a stalemate, but I would suggest that this is something that really needs to be pursued, because potentially evidence of a plan or an intention to commit genocide is something that could be found within the Facebook information and data. So it's critical.
Thank you for that comprehensive sort of discussion on the evidence. So 3 points which sort of flow into the discussion. Do you see or do you expect the court to perhaps issue an order under Article 50 for expert opinions? So that's question one. Going forward, do you see, because we have these parallel proceedings, a sense of a sort of an interjurisdictional sharing of evidence between the ICC and the ICJ? And finally, do you see the evidence which the IIMM has collected so far? Do you see sort of an impediment to taking a successful case at the ICJ with the evidence that the fact-finding commission has thus far? Or do you see that more needs to be done in terms of evidence to prove a genocidal intent?
I mean, I'll come to your last question first, right? I mean, one is what is available publicly. So if you look at the FFM reports, 2018, 2019, and I come to 2019 specifically because this was brought up at the ICJ hearings where, the FFM report in 2019 says very clearly that the possibility of genocide or the evidence that genocide may have occurred is probably even higher in 2019 than it was in 2018. So they've clearly done a fairly rigorous analysis of what they think might have happened. I think, the one thing is that, of course, we have information or we have access to what is public and what has been put up by the fact-finding mission. They also have a repository of information behind the reports that are not necessarily being made public, right? I mean, it's linked to witness confidentiality, it's linked to highly sensitive evidence. And, the assumption is that that information, not just the public-facing information, has gone to the IIMM. So it's now for the IIMM to look at the information and the evidence that it has. And if you look at the terms of reference of the IIMM, it's very clear. The terms of reference really talk about the standard of proof. It talks about the evidentiary requirements, essentially that it should be able to be sort of held up in court as well. So they're looking at the evidence from a very, very specific angle and really with a view to future court proceedings as well, right? So, I mean, I think there's that connection between the FFM and the work it's done, which now is over and has been transitioned and handed over to the IIMM. There's also, as you say, there are continuous, sort of the parallel proceedings right now. There seem to be no barriers that would preclude these international legal institutions from coordinating with each other. And, having said that, of course, you'll have a different focus. So the ICC right now is going to be focused on the deportation case and accessing evidence and information from predominantly the refugee community that is in Cox's Bazar. The ICJ would have a slightly different approach. And again, it's going to be very much dependent on what the parties bring to it. So again, very clearly, the ICJ, it is an adversarial proceeding. Like the ICJ has said in numerous cases, we rely upon a check by the respondent. So the burden of proof is on the party that brings the case to court. But of course, the veracity of that evidence or the challenging of that evidence is also going to depend on what the respondent state brings to us. But yes, I mean, I don't see any reason why the ICJ would not also call for expert opinions. Quite possibly even members of the fact-finding mission. I mean, I would think that they would be very obvious. Again, the Gambia has relied heavily and extensively, as you would have seen in the application, on the FFM report. So yeah, I mean, I think that the ICJ has a broad scope, of course, within the context of what the parties bring to it as well. So I think, the Gambia and the legal team there have to have a very clear idea of their strategy, their legal strategy, and what they're going to bring to court and, the manner in which they want that evidence appreciated by the court as well.
Thank you for that, Priya. So now I have a question. I mean, a lot of people are looking at this development very closely, and not least people on the ground in Myanmar. And given the gravity of the case, given what it involves, given how significant it may be, how do you see this progressing going forward? What do you see it looking like? And given the ICJ's history with, for instance, the Bosnia versus Serbia genocide case, they issued a provisional measure order in 1993, and then the merits judgment was rendered in 2007. Is that something we should be expecting now? How is it looking?
Yeah, I mean, I think, looking at Bosnia versus Serbia, the first provisional measures order was April 1993. There was a second provisional measures order in September 1993. And then the genocide in Srebrenica happened in 1995. So I don't know. I mean, in terms of, the way that the court has been more proactive in this case, my speculation, and it's purely speculation, is possibly that it's a bit haunted by, what happened in 93 and 95, and perhaps the perception that it wasn't strong enough. Maybe that the provisional measures order, if you look at both the orders, were couched within, the standard Article 41 provisional measures that you usually get, which is cessation of hostilities. These are obligations that, of course, you're asking a state to undertake. But I think in this case, perhaps maybe that's why the court has definitely gone further and said, implement it, send us monitoring reports, access, and make sure that the evidence is kept safe and not destroyed. So I think, of course, it's speculation, but I would think that would be a reason partly impelling the urgency on the part of the court. Now, having said that, I think in terms of on the ground, I think maybe a sort of inkling of what that reaction is like can be, gleaned from the hearings in December. So if you all recall, 10th to the 12th of December, there were hearings at the International Court of Justice, and you had the Gambia, presenting its case, and then you had Myanmar, and you had the State Councillor for Myanmar, Aung San Suu Kyi, coming to the International Court of Justice, basically defending Myanmar. And I think the optics of what's going on at the International Court of Justice also become very, very important back home. And I mean, we've all seen this also in the Jadhav case and in a lot of other cases, right? I mean, it plays to an audience at home as well, which goes beyond the legal. And I think in the case of Myanmar, I mean, it seemed really to be a consolidation of Aung San Suu Kyi's position in a way, and possibly the implications that are going to sort of continue through this year, including elections that are coming up in November. So I think there are many, many sort of domestic ramifications, which probably I don't know enough about as well. But I think that is going to play out in the domestic level, apart from what happens internationally and apart from the legal argumentation. And I think the one other thing that I will say, of course, is in the legal arguments at the ICJ, it was a bit of a strange position where the counselor actually argued, perhaps there were crimes against humanity. And perhaps there were crimes that occurred, but we are dealing with it within the military justice system within Myanmar. And we are dealing with it, having set up an international commission of inquiry and, basically saying, look, we've got our legal mechanisms domestically and they are going to handle this. I mean, to be honest, I thought that argument should have been geared more towards the International Criminal Court, because it played more to the discussion around complementarity, really, and what is happening in your domestic proceedings. But I think it was also, part of the strategy to say, really, there's no need for this case to go forward. But it's going to play out in a different way, where I think we've seen immediately after that, the two Reuters journalists who had been imprisoned were released. So there was some domestic sort of movement in terms of saying, look, we're genuine and we're actually doing this. But I'm not sure that that's going to continue. And, there are huge questions around the Commission of Inquiry, the mandate, the way it's been set up, and that it's a whitewash, basically. So, yeah, I think massive ramifications across the board, domestically, politically, and legally.
Right, great. That brings us to an end of the podcast. I'm glad you brought up the Yadav case. It gives us an excuse to bother you again. So hopefully we'll do that soon. And yeah, I guess that was a very insightful session on the Gambia versus Myanmar case. And we'll see you in the next episode.
Thank you very much. It was a pleasure to chat to you.